Hello, everyone, and thank you for attending today's webinar on updates in non-compete law. My name is Ryan Gabauer, and I am joined today by my colleague Zoe Spector. Over the next hour, we are going to guide you through the ever-busy climate of non-compete legal updates. But before we begin, I just wanted to cover a few housekeeping items. If you have any questions during the webcast, you can submit them through the Q&A widget. We will certainly try to answer these questions during the webcast, but if a fuller answer is needed or if we run out of time, the question will be answered later via email. If you experience any technical problems during the webinar, those can also be reported through the Q&A widget. A copy of today's slide deck is available in the resource widget. We encourage you to download any resources or links that you may find useful. And you can find additional answers to some common technical issues located in the Help widget. This webinar is CLE accredited for 1 hour of general credit in California, 1 hour of general credit in Illinois, 1.2 hours of general credit in Missouri, 1 hour of professional practice credit in New York for experienced and transitional attorneys, and 1 hour of general credit in Texas. This program has also been submitted for SHRM and HRCI credit. CLE credit is awarded based on full attendance. To verify engagement and to make sure you all are still awake, secret words will appear in multiple choice polls during the webinar. Please respond to these polls to receive full credit. We thank you very much for attending. We greatly appreciate your opinions, and we appreciate your participation in the course. Just to give a brief overview of today's presentation before we jump in, by now most of you are likely aware that the Federal Trade Commission under the Biden administration issued a rule in 2024 banning most non-competes. Not to bury the lead, but if you look at the first item on the agenda, you will notice that the nationwide non-compete ban from the FTC has come to an end. So Zoe will give you an update on that status, and then she will cover the FTC's current approach, which is a case-by-case targeted enforcement approach. And then she'll discuss the impacts this approach is having on employers. The presentation will then shift to me, and I'll provide a brief overview of recent statewide legislative trends for non-competes. I'll talk about some new and recently proposed state legislation, and then we will cover some of the impacts and challenges to employers, particularly multi-state employers that have come about from this recent legislation. Zoe is going to wrap up the presentation discussing some alternative options to non-competes, and she'll cover some best practices for employers in the current and quite wild non-compete legal landscape. So we have a lot to cover in the next hour. We are certainly going to do our best to get to any questions during the presentation. If you have any, please do put them in the Q&A widget. And we're happy to answer any questions that we don't get to if we run out of time. So now I'll turn it over to Zoe to give some updates from the FTC.
Thanks, Ryan. So back in April of 2024, the FTC, as Ryan mentioned, issued a rule that banned non-competes nationwide. And this ban prohibited any employer from entering into new non-compete agreements with an employee. It prohibited the enforcement of existing non-competes, and it had very limited exceptions. And this rule banning non-competes with very limited exceptions was set to take effect, as a lot of you may know, on September 4th, 2024. The same day the FTC issued the final rule, a global tax services and technology firm, Ryan LLC, sued the FTC to vacate and set aside the rule in the United States District Court for the Northern District of Texas. Federal, state, and local chambers of commerce and business associations were eventually permitted to intervene in this litigation, and I would be remiss not to add that similar lawsuits were filed in other jurisdictions as well. On August 20th, 2024, the court granted summary judgment in favor of the plaintiffs which included Ryan LLC. This permanently set aside the FTC's rule banning non-compete agreements nationwide. The court found that Section 6G of the FTC Act does not authorize substantive rulemaking, which meant the FTC did not have the statutory authority to promulgate the non-compete ban, as it was a substantive rule. On October 18th, 2024, the FTC appealed this decision to the Fifth Circuit Court of Appeals, arguing a different interpretation of the FTC Act, which they argued did give them the authority to issue such a rule. And while that Fifth Circuit appeal was pending, we elected a new president. And in January 2025, President Trump designated Andrew Ferguson as the chairman of the FTC. And on September 5th of 2025, several months later, the FTC under the new administration did take steps to dismiss its appeal before the Fifth Circuit. This means that the FTC is no longer going to litigate whether it has the power to issue a nationwide ban. And Judge Brown's August 20th, 2024 decision stands. This means that the FTC is acknowledging that they do not have statutory authority to issue the rule banning non-competes at the federal level. So a lot of you may be thinking, well, what's the plan now? There's no more nationwide ban. So what is the FTC up to? Well, the FTC has made it clear that they are no longer pursuing the ban. And the following alert is displayed on the FTC's website where the April 2024 rule was announced. And as you can see, it says, the rule is not in effect and it is not enforceable. On August 20, 2024, a district court issued an order stopping the FTC from enforcing the rule. The FTC appealed that decision, but on September 5th, 2025, the FTC took steps to dismiss its appeal in the Fifth Circuit. So the FTC is being very transparent that this is their position and they're standing by it. While the current administration is no longer pursuing a nationwide ban, it is nonetheless invested in preventing unfair non-competition agreements and is taking a dynamic approach toward enforcement measures. On September 4th, 2025, the FTC launched a public inquiry to better understand the prevalence and impact of non-compete agreements on employees. The interesting point here is that the FTC, under this presidential administration, does not necessarily disagree with the basic fundamental public policy reasons for the prior administration's attempt to issue a nationwide ban, which was to protect employees from methods of unfair competition. Rather, this FTC argues it lacks the statutory authority to issue the rule, and instead finds that most productively the FTC can use its enforcement powers to prevent the use of non-compete agreements as unfair methods of competition by bringing individual targeted enforcement actions against employers. In doing so, the FTC is engaging in targeted efforts against employers who it considers to be the worst offenders. When the FTC began this targeted enforcement effort, it issued a statement on September 4th, 2025, stating, "We are asking the public to help shine a light on unfair and anti-competitive agreements. Unreasonable non-compete agreements have proliferated for too long in the dark. With the assistance of the employees and workers most burdened by them, the Trump Bans FTC intends to uproot the worst offenders and restore fairness to the American labor market. We look forward to working closely reviewing every response." The FTC also emphasized that the Trump Bans FTC has prioritized investigating and prosecuting deceptive, unfair, and anti-competitive labor market practices, including through the creation of a cross-agency joint labor task force. Federal Trade Commission issues requests for information on employee non-compete agreements. And so that opened up the door to accept public comments on how employees find that non-compete agreements are impacting their ability to seek employment and maintain employment and be competitive in the market. On September 4th, 2025, the FTC ordered the largest pet cremation business to stop enforcing restrictive non-compete agreements that bound almost 1,800 workers. So this was sort of the seminal first big enforcement action the FTC has taken in the Trump-Vance administration. In the complaint the FTC filed against Gateway Services, which was the company at issue, it alleged the company imposed non-compete agreements on nearly all of its employees, regardless of their position or responsibilities, except those working in the state of California. The non-compete agreements at issue in that case typically prohibited employees from working in the pet cremation service industry anywhere in the US for 1 year after leaving the company. On November 25th, 2025, according to the FTC, the commission finalized a consent order against Gateway Services. As part of that consent order, along with other explicit instruction and compliance issues, Gateway Services was ordered to immediately stop enforcing all existing non-compete agreements. On September 10th, 2025, the FTC warned employers in the healthcare industry that it was one of the targets of FTC's enforcement measures in ensuring such companies are not using non-compete agreements as unfair methods of competition. In a public statement issued by the FTC regarding the issuance of these healthcare letters, the FTC stated many healthcare employers and staffing companies may include unreasonable non-compete agreements in employment contracts for vital roles such as nurses, physicians, and other medical professionals. These restrictions can unreasonably limit healthcare professionals' employment options, thereby limit patients' choices over who provides their medical care, including critically in rural areas where medical services are already stretched thin. The FTC also stated that enforcement against unreasonable non-compete agreements remains a top priority for the FTC. The FTC is strongly encouraging all employers, not just those in the healthcare industry receiving letters, to review their contracts closely to ensure that any restrictions on employee mobility are in full compliance with the law. So as you can see here, the FTC is starting its enforcement measures by focusing on who they consider to be the worst actors, and also within the healthcare industry more broadly. Yesterday, the FTC held a workshop. It was a webinar, and the title of it was Moving Forward, Protecting Workers from Anti-Competitive Non-Compete Agreements. In this webinar yesterday, the FTC reviewed its position and re-emphasized its enforcement priority to prevent anti-competitive non-compete agreements. During this webinar, there were even 4 individuals who the FTC considered to be victims of unfair anti-competitive non-compete agreements. They shared their stories and provided statements on behalf of the FTC to re-emphasize the FTC's enforcement priority in this space. Chairman of the FTC, Andrew Ferguson, himself, in a keynote address during this webinar, stated that if an employer wants to have a non-compete agreement, they best be prepared to defend it. So making pretty clear the FTC's position on this issue moving forward. So some of you may be wondering, what does this all mean for employers? Well, the shift away from a federal nationwide ban on non-compete agreements to a focused, targeted enforcement effort first and foremost means that employers should be reviewing their form employment agreements and any existing employment agreements that may be out there already in effect, and making sure that they do not include non-compete provisions or other restrictive covenants that are not appropriately tailored to serve the employer's legitimate business interests, and should take a look at which employees the company may actually benefit from having non-competes with. My colleague Ryan will soon discuss the variety of restrictions from a state level, which further emphasizes the need for a non-uniform approach. And Ryan will dive deeper into these best practices later in the presentation. As for the practical implications of not having a one-size-fits-all federal approach to non-compete agreements, there very well may become too many state laws that it becomes arduous and overly burdensome for employers to require new non-compete agreements or to enforce existing non-compete agreements. The jurisdictional restrictions and limitations are likely going to cause employers to expend a lot of resources to ensure compliance. And if they haven't already, employers may begin to fade out some non-compete agreements for certain groups of employees altogether. The overall benefit of non-compete agreements for certain employers may go down, and employers may begin to rely more heavily on NDAs, confidentiality and proprietary right agreements, causing such agreements to become more prevalent in an employee's repertoire of tasks to consider when starting a new job, leaving an existing job, or on the market for a new job. The lack of a one-size-fits-all solution at the federal level has also caused more movement at the state level for state legislatures to enact more comprehensive laws and regulations to limit or ban non-compete agreements by the state. In other words, if anything, multi-state employers have more state laws and guidance to comply with now more than ever.
All right, let's talk about all the statewide laws that are making non-competes even more complex by the day. So before we dive into updates from this past year, I just want to give a brief overview of the recent trends that we're seeing in the state laws, which I think will help set the stage for our discussion. So the state-to-state variety in non-compete laws is nothing new. It has been quite rampant for the past few years. In fact, prior to 2025, more than half of the country had laws on the books either banning or restricting non-competes in some fashion. And the laws passed over the last year and some that have been proposed so far in 2026 have certainly continued this trend, which I'll talk about here in just a minute. As you can see from the slide on the screen, there are currently statewide statutes banning or limiting non-competes in most states. This slide gives a little bit more context, giving a quick rundown of the common statewide non-compete laws. As you can see at the top, there are 4 states, California, North Dakota, Oklahoma, and Minnesota, that currently ban employee non-competes with very narrow exceptions. There are also various state laws banning non-competes for specific industries. Zoe just mentioned a focus on the healthcare industry, and there's some specific bans on professions in the states. There are also 12 states plus Washington, D.C. that allow non-competes, and in some states, non-solicit agreements only against employees earning above a certain compensation threshold, or against employees who are exempt under the Fair Labor Standards Act, or against employees with certain job functions or positions like a sales employee. At least 12 states plus Washington, D.C. also have laws specifying the outer duration of an enforceable non-compete. Another recent trend in state legislation is to require advance notice to employees or to give them time to consider the covenants before executing the agreement. And there are currently 9 states plus Washington, D.C. with these laws. And then lastly, we just want to highlight there's 8 states plus D.C. that includes statutory penalties for violating the non-compete law, and in some cases, even criminal liability for violations. For those of you who prefer visuals, I think this map is rather telling with the level of variety from states to state. You can see that nearly every state has legislation that bans or restricts non-competes. The 8 light-colored green states do not currently have any such laws on the books. But if we were to consider proposed legislation, almost the entire map would be a darker shade of green. So before we talk about new laws over the past year, let's discuss a little bit more about the types of common non-compete laws already in place. Now, we're certainly not going to go in depth into all the intricacies of this pre-2025 state legislation. We would, I think, need well more than an hour just for that. But I just want to briefly give a little bit more detail about the frequent types of state laws on non-competes. So as I mentioned, one of the common legislative trends is to ban non-competes and in some states non-solicits against employees who do not make a certain amount of money. There are currently 11 states plus DC that have this type of law currently on the books. And the chart in the slide lists the most up-to-date 2026 salary thresholds in the states and DC that have these salary threshold laws. It's important to note that in 6 of these locations, so Colorado, Maine, Oregon, Rhode Island, Virginia, Washington, and Washington, D.C., the salary threshold increases on an annual basis. So if you have employees in these locations that are subject to a non-compete or a non-solicit, I would strongly recommend not executing that agreement and then just putting it off on the shelf to be unaddressed for years, because you need to check on an annual basis whether that employee's pay is still satisfying the annual salary threshold. I also want to highlight Colorado's salary threshold requirement. It is quite an odd one, in fact. So in Colorado, the employee needs to be earning the annual salary threshold, which is increasing on an annual basis. They need to be earning that annual salary threshold at the time the employee enters into the non-compete and or non-solicit, and at the time these covenants are enforced. So this means, if you think about it, that before an employer attempts to enforce a non-compete or non-solicit against a former employee, the former employer needs to somehow know how much money the former employee is making at his or her new job, which is obviously information that the former employer may not know. And so that's a very oddity of Colorado that's tricky to navigate. As I also mentioned earlier, there are 9 states plus DC that require employers to give employees varying amounts of advance notice before the non-compete can be enforceable. So this slide and then the next slide lists the states that have these advance notice requirements. I'm not going to read through each one, but a couple important points to note. Most of the laws have different notice requirements depending on whether the individual is asked to sign the agreement before or at the start of employment, or whether a current employee is asked to sign after employment has already started. Most of these notice requirements apply also to non-solicits in addition to non-competes, so keep that in mind. And then there's a couple of notice requirements I do want to specifically highlight. So most of these states that have notice requirements require advance notice before signing the agreement, but Oregon also requires employers to provide employees a copy of the signed non-compete within 30 days after termination of employment. And then Colorado is back with another oddity, as it requires a separate signed notice that includes a copy of the non-compete and non-solicit and some very specific notice language to be included. And then Virginia requires employers to post a notice in the workplace that discusses the Virginia law that bans non-competes against low-wage earners. And the Virginia law actually is one of those states that attaches statutory penalties, which would include for violations of the poster requirement. So this chart, like I mentioned, lists the remaining 5 states that have the advance notice requirements. Another common trend in state legislation is to restrict choice of law and choice of venue provisions. So we're seeing with more and more states passing laws with very specific non-compete restrictions, you're seeing this choice of law and choice of venue much more frequently. And these laws prohibit employers and employees from agreeing to choose the law of a state other than where the employee resides or works as the governing law of the non-compete agreement. And as you can see in the slide, there are 8 states with these types of restrictions. A few miscellaneous non-compete laws to be aware of. In Maine, non-competes cannot take effect until the later of after 1 year of employment or 6 months from the date the agreement is signed. In Massachusetts, in addition to prohibiting non-competes against non-exempt employees under the FLSA, Massachusetts says that non-competes cannot be entered into with employees 18 years old or younger, or with undergraduate or graduate students working part-time. Massachusetts also says that non-competes cannot be enforced post-employment if the employee is terminated without cause, which the statute conveniently does not define what cause is, or if the employee is laid off, can enforce a non-compete post-employment. And then lastly, Massachusetts requires, for enforcement of post-employment non-competes, it requires employers to have to pay employees throughout the restricted period at least 50% of the employee's highest annualized base salary during the 2 years before the employee's termination. As I mentioned earlier, there are also 7 states plus DC that entitle the state to seek statutory penalties for violations of its non-compete law. And it's important to note that these statutory penalties are, of course, in addition to any damages, which often include attorney's fees and injunctive relief that the individual employees can seek. As I mentioned, and as you can see on the slide, there are 4 states, California, Colorado, Nevada, and Oregon, that actually attach criminal liability as a misdemeanor for violations of their non-compete laws. The civil penalties are usually around $5,000 or $10,000 per employee and or per violation is how the laws are typically written. But Maine has a unique one that provides for no less than $5,000 without giving any cap. Another noteworthy point for these penalties, DC and all of the states except Nevada allow the government to seek penalties for violations of the statute that would include just entering into a non-compete that does not comply with the state's law. So the employer does not need to actually be trying to enforce the non-compete for these penalty provisions to attach, or for the employer's non-competes to catch the attention of the state. Also, not to pick on Colorado, but recall the oddity with its salary threshold restriction, that it needs to be met at the time of enforcing the restrictive covenant, and how difficult that is to know, and that you're doing that in compliant with Colorado law. So for any Colorado employers that have employees subject to non-competes, I would strongly consider that requirement along with the risk of civil penalties and criminal liability under Colorado law before possibly enforcing a non-compliant restrictive covenant. Okay, now we have come to the time of today's first secret word. Today's first secret word is movie. Please select the correct word below. All right, hopefully you all got the secret word. So now let's talk about how 2025 and the first month of 2026 have continued to complicate non-compete laws. So this slide gives a quick rundown of the new and proposed laws since last year. As you can see, the first 2 bullet points, there have been more than 80 and counting bills introduced across 37 states. And there have been 15 and counting new state laws on non-competes. These new and proposed laws have certainly shown a greater focus on compensation and job function thresholds for restrictive covenants. And again, a greater focus on limiting or banning non-competes in the healthcare industry, consistent with the FTC's approach that Zoe mentioned. So what you're going to find with these new laws, and this has really been the case for a while, but you're going to find I think even more so now with all of the recent changes, that there, as Zoe mentioned, is really no one size fits all approach for your employee restrictive covenants, especially if you have employees across multiple states. It is becoming even more complex and difficult to draft and enforce a uniform non-compete agreement across your workforce. So after we cover the new 2025 and proposed 2026 laws, we'll talk a little bit more about how these complexities may make employers rethink the cost-benefit analysis of executing non-competes. All right, turning to the first new non-compete law. In 2025, Wyoming joined the group of states banning most non-competes with some narrow exceptions that are listed in the slide. A few interesting notes. The law exempts non-competes entered into with executive and management personnel and officers, as well as the employees constituting their professional staff. But it, isn't easy enough that it gives a definition of those terms, and there's no guidance as to the employees who would fall under that bucket. So keep an eye out for any updates on that front if you have Wyoming employees, as that is open for future interpretation. The Wyoming law, like a lot of non-compete laws that we're seeing, clarifies that non-competes are okay if protecting trade secrets. The law also expressly okays alternatives to non-competes that may help retain employees, such as contracts entitling the employer to recover any paid costs for moving expenses, education, and training expenses should the employee not stay employed for a certain period of time. Unlike other bans that we've seen, the Wyoming statute does not expressly exempt non-solicits from the law. It doesn't even address non-solicits, so it's currently unclear whether non-solicits, primarily customer non-solicits, are okay in Wyoming. New York has a near complete ban that's currently pending. In February of 2025, it proposed a bill. Some of you may recall that the New York legislature passed a near complete non-compete ban a couple of years ago that was vetoed by the governor. And the main reason that she vetoed the bill was because it lacked any carve out for non-competes against high-paid workers. So in response to the governor's veto, this new proposed bill in New York would allow employment non-competes against employees making $500,000 or more per year. But for those non-competes for high-earning employees, the non-competes cannot exceed 1 year post-employment, and the employee is entitled to salary payments during the post-employment non-compete period. So it's essentially a garden leave provision. I would anticipate, based on the bill including the carve-out that the governor wanted, I would anticipate this bill passing in the legislature and being signed into law by the governor. Sorry, I thought I skipped a slide. We are also starting to see, maybe unsurprisingly because the FTC rule ended, we're starting to see states propose legislation that closely mirrors the FTC final rule. And New Jersey is one example of this. So New Jersey proposed a bill that would ban all non-competes entered into after the effective date of the bill, except for those entered into in the sale of a business context. And also, just like the FTC's final rule, the New Jersey bill, if passed, would retroactively ban non-competes, except non-competes with senior executives that have a 1 year post-employment restriction with limited geographic scope and garden leave compensation. So compensation throughout the non-compete period. The New Jersey proposed law defines senior executive the same as the FTC rule, and that is a worker who is in a policy-making position and is paid above a certain compensation level. The New Jersey rule, also like the FTC's rule, requires notice to employees within 30 business days after the effective date of the law, if it passes, that any non-compliant existing non-compete will not be enforced. So if all these various restrictions across the states are not enough to make your head spin, Florida and Kansas have bucked the trend to add pro-restrictive covenants to the mix, pro-restrictive covenant laws to the mix, I should say. So on July 1st, 2025, Florida passed the Choice Act, which, among other things, creates a presumption that 4-year employee non-competes are enforceable against employees earning twice the annual average wage of the Florida county where the employer's principal place of business is located. The Choice Act also, unlike most non-compete laws, puts the burden of proof on the former employee. The law notably requires courts to issue injunctions enforcing compliant non-competes unless the former employee can prove his or her new employment will not result in unfair competition. And then Kansas, also on July 1st, 2025, added an employer-friendly law when it amended the Kansas Restraint of Trade Act, which clarified that certain customer and employee non-solicits are valid and enforceable and are not restraints on trade that are to be analyzed under Kansas law like non-competes. All right, now let's talk about some new income-based restrictions. Also on July 1st, 2025, Virginia expanded the definition of low-wage employees who cannot be subjected to a non-compete to include all non-exempt employees under the FLSA, regardless of the salary that the employee makes. There are 2 new states, New Hampshire and Indiana, that have proposed income restrictions for non-competes earlier this month in January. So New Hampshire seeks to amend its existing income restriction for non-competes that would increase the salary threshold from 200% to 500% of the federal minimum wage. But also the New Hampshire amendment would limit post-employment non-competes to 12 months. And then Indiana introduced a bill in January to ban all non-competes for employees making less than $150,000 per year. So as Zoe mentioned, a focus of the federal government is on limiting non-competes in the healthcare industry, and the states have definitely followed suit. In addition to the number of non-compete laws banning or restricting non-competes against healthcare professionals already, there in 2025 were 5 states, Arkansas, Indiana, Montana, Utah, and Wyoming, that passed laws banning non-competes against physicians and in certain of these states against other medical professionals. There also have been 5 states, Colorado, Maryland, Louisiana, Pennsylvania, and Texas, that passed laws or amendments to existing laws that are further restricting the use of non-competes against physicians and other healthcare professionals. And this slide goes through all of those. And then lastly, there's been 5 states, New Hampshire, Missouri, New York, Virginia, and Vermont, that have proposed laws that would ban non-competes in the healthcare industry. So if these 5 proposed laws go into effect, we'd have more than 60% and probably growing of the states that either ban or restrict non-competes in the healthcare industry. So there's also been some notable miscellaneous non-compete restrictions in 2025 and 2026. Massachusetts passed a new law stating that only the actual employer, not a parent or grandparent company, can sign and enforce a non-compete against employees. Virginia is trying to further the trend of requiring payments during the non-compete period with a bill that would make non-competes unenforceable if the employee is terminated without severance. And this Virginia proposed bill also limits the duration of any non-compete for the period the employee is receiving severance. And then finally, Utah, like Virginia, is proposing a bill that would require full salary payment to an employee during the non-compete period. Utah's bill would also prohibit non-competes against independent contractors and employees making $155,000 per year or less. And it also would prohibit non-competes against employees terminated without cause. And of course, the Utah bill, like the Massachusetts law, does not define what cause is. So I think this, at least for these two states, underscores the importance of defining cause in the agreement with the non-compete, and also in that agreement providing for continuation of salary benefits during the non-compete period that would comply with those two laws. And now I'll turn it back over to Zoe, who's going to discuss some alternatives to non-competes.
Thanks, Ryan. So some of you may be thinking, so what can I do to protect the company from unfair competition by current and former employees, aside from trying to enter into a non-compete agreement that may be enforceable and defensible in whatever jurisdiction you're in? So some of those alternatives include the obvious, such as customer and employee non-solicitation agreements. And a lot of you may know, but these are agreements that prevent past and present employees from soliciting customers and/or employees or other agents of a business. They're typically more narrowly focused and less scrutinized by courts. And as Ryan mentioned earlier, there are certain states, such as Illinois, that also impose statutory restrictions on non-solicitation agreements. There are also some states that have laws banning or restricting non-competes that explicitly exempt non-solicitation agreements. So this is also, unfortunately, not consistent state by state. It's always best to consult with counsel to prepare any of these types of agreements. Non-solicitation agreements can sometimes be interpreted by courts as having the effect of being a quasi-non-compete agreement due to restricting and/or limiting an employee's ability to compete by working with former employees and/or customers. However, as mentioned, they are generally less scrutinized by courts compared to traditional non-compete agreements. Another alternative is a forfeiture for competition provision. So courts vary on whether these are enforceable. This is in part because under certain circumstances, forfeiture for competition provisions can be interpreted as non-compete agreements. These are more common. Having a forfeiture for competition provision can be more common in a partnership type of agreement as opposed to a traditional employment agreement. And the Supreme Court of Delaware recently conducted an in-depth analysis on the enforceability of forfeiture for competition provisions in the 2024 case, Cantor Fitzgerald. The provision at issue in that case was one that authorized the partnership to withhold distributions otherwise owed to a partner who withdraws from the partnership if he or she engaged in certain activities that were considered to be in competition with that person's former partnership. The provision of the partnership agreement in that case specifically remained in force for 4 years following the partner's withdrawal from the partnership. The Supreme Court of Delaware in Cantor Fitzgerald found that it should not analyze forfeiture for competition provision using a reasonableness standard as they would for a non-compete agreement. Instead, the court concluded that it's purely a matter of contract law and the parties have a right to enter into a contract that results in such forfeiture of payment in exchange for competition. The court found, and I quote, "The distinction between a restrictive non-competition covenant that precludes a former employee from earning a living in his chosen field and an agreement that allows a former partner to compete but at the cost of relinquishing a contingent benefit is, in our observation, significant. In the restrictive covenant context, the former employee is effectively deprived of his livelihood and correspondingly exposed to the risk of serious financial hardship. This gives rise to the strong policy interest that justifies the review of unambiguous contract provisions for reasonableness and a balancing of the equities, two exercises typically foreign to judicial review and contract actions. By contrast, however, forfeiture for competition provisions, which, unlike restrictive covenants, are not enforceable through injunctive relief, do not prohibit employees from competing and remaining in their chosen profession, and do not deprive the public of the employee's services, and they present no such concern. The policy interest that preponderates in the former case is diminished, if not vanished, in the latter. To put it another way, the interest to be vindicated when evaluating a covenant that prohibits competition and that might even preclude gainful employment is significantly weakened when competition, often, as in this case, highly remunerative, is permitted. As a reminder, this case was specifically analyzing a partnership agreement under Delaware law. So a very specific example, but a very succinct explanation of the differences that the Delaware court found in this specific case under this specific set of facts between a non-compete agreement and the forfeiture for competition provision in that partnership agreement. Another alternative is something Ryan mentioned earlier, which is garden leave clauses. So some states require garden leaves for non-competes now anyways, as we saw with some proposed and enacted legislation throughout the states. We may see this more often moving forward as a way to rectify some of the policy reasons against having non-competes, in the sense that state legislators may start imposing pay requirements during non-compete time restrictions. So although garden leave clauses certainly delay an employee's ability to join a competitor and remove them from current information relevant to their employment and getting those experiences, they are being compensated for it. So it's a lot of states are more in favor of garden leaves as a matter of public policy. Another alternative is a training repayment agreement or retention bonus. And again, this may be something you see quite often, and it seems pretty obvious, but it can be actually used as a great tool in lieu of non-competes in a lot of ways. So these are an agreement where an employer pays costs for an employee to receive work related to training or education, or the employee receives a bonus under the condition that they remain with the employer for a set period of time. The employee, if they leave prior to the expiration of the set period, then they must repay some or all of the costs of the training or education or forfeit the right to the bonus. This protects employers and their investments into their employees. And this does serve somewhat of a different purpose compared to a non-compete, though training repayment provisions and retention bonuses in a lot of ways still protect employers from having employees who compete with their business, as it is founded upon the employer's protection of its investment in training or other specific experience that the employer provides to the employee. Another common alternative to non-competes, which I do think we'll start seeing a lot more now instead of non-competes, is a well-drafted NDA. A well-drafted NDA can certainly accomplish many of the same ideals as a non-compete agreement, such as the protection of an employer's confidential interests, as NDAs do not restrict an employee's ability to compete, but rather an employee's ability to use certain information gained from an employer. An NDA is a practical and useful tool to prevent an employee from exploiting an employer by unfairly using confidential information against it. Another alternative to non-compete agreements is a protection that employees must provide their employer while they're employed, which is to not actively compete and breach the fiduciary duty. And it's a good idea to also paper this in employment agreements, as I'm sure a lot of the listeners here already do. And this is founded upon the common law of duty of loyalty on employees to act faithfully to their employer during employment. Without being contractually bound to a non-compete, the duty of loyalty and actions for the breach of this duty can prevent employees from improperly competing during employment. So this is more so focused on during employment, but still something important to be considering. Okay, we have another secret word. and that is award. Please select the word award below. Okay, I'm gonna move on, thank you. So finally, we're gonna wrap up the presentation section of our CLE with some best practices heading into 2026. As Ryan and I have emphasized over the past 50 minutes, the landscape of non-competes is ever changing. It's being heavily scrutinized at the federal level, and it is being heavily restricted or banned at the state level. So this certainly creates a lot of conflict between how to move forward for a lot of our multi-state employer clients. So some best practices for multi-state employers is to consider whether a non-compete agreement is necessary. And again, that does seem like an obvious question to be asking, but it is important to really consider who values or which employees would benefit from having the non-compete for purposes of the employer protecting its unfair competition advantage in whatever industry or space you're in. So you should be considering the groups of employees, how much money those groups of employees earn, and what the state law says on that you're in, like jurisdiction specific agreements. Should be considering whether there are alternative protections, confidentiality and trade secret agreements, non-solicitation agreements, intellectual property and ownership provisions, garden leave or forfeiture for competition clauses where permitted by state law. Rethink governing law provisions if you can, if you're in a jurisdiction that allows you to do that. But by doing that, you could consider what state is most favorable to enforce whatever what type of restrictive covenant or non-compete you're attempting to defend. You can narrow restrictions to ensure that they are tailored to legitimate business interests, such as I was stating earlier, making sure you're only entering into these agreements with certain groups of employees who, let's say, meet a certain salary threshold or have access to certain levels and to a degree of trade secret and confidential information that causes you to have a legitimate business interest for them to enter into a non-compete agreement. Should always consider whether the duration, geographic, and activity scope is reasonable. And should always consult with counsel to track state and federal enforcement trends and legislative updates. Now, up on the screen, this is just a good checklist moving forward as a takeaway to sum up our presentation. You should always consider where the employee resides or works when considering whether to prepare and enforce or defend a non-compete. The level of the employee's compensation and exemption status, the employee's profession, industry, and job function, what the purpose of the restrictive covenant is, if it's defensible in terms of being narrowly tailored to serve a legitimate business interest. Should consider whether there are some more enforceable alternatives, such as non-solicitations, NDAs, proprietary right agreements, and more easily enforceable garden leaves. Are you in a jurisdiction where you can contract for choice of law or venue? Are you in a state where the courts blew pencil or engage in judicial reformation of contracts? And you should make sure always, and this isn't something we really went over, but when you're entering into these, making sure that there's sufficient consideration and whether that the level of sufficient consideration is dictated by this, if a state law, if there is one on the matter. So that ends the presentation portion of our CLE. So now we have about 4 to 5 minutes to answer some questions.
Hey Zoe, I got a couple questions in. The first would be, and I can give an answer for this, but what would you tell a client who asks you to prepare a single restrictive covenant that they can use for all employees nationwide? I think I would start with finding out where those employees are, because there are certain states, that we've mentioned, Colorado, California, for example. California we didn't even touch on. You can't have non-competes, but I think you need to be more so cognizant now of the ramifications for entering into a non-compete that doesn't comply with all the applicable laws, even if your goal is to not really enforce the non-compete. I've heard a lot of times clients want to have non-competes to serve as a scare tactic to keep employees honest. Now we have situations where just doing that could result in some statutory penalties, some damages if there was a lawsuit. So you really need to take a step back and think if that's even going to be a worthwhile endeavor. I have another question, Zoe. I don't know if you wanted to add anything to that. We get to probably have time for one more question.
No, I think that covers it. I would also just add to always be consulting with your employment counsel, because due to these ever-changing multi-state laws and the federal government's new enforcement priority for non-compete specifically, it's important to just be kept up to speed on what the law says, which, as we went over, could really change at any given time.
Yeah, I think a starting point is really assessing or taking a real hard look at what employees actually need to have a non-compete to protect your interests. So another question, Zoe, I'll propose this to you. With the FTC's recently communicated approach of this case-by-case enforcement, I mean, this is really new territory. We haven't had the federal government come out and really give this approach publicly. So is there anything else noteworthy that came out of the FTC's webinar yesterday that you think would be helpful for folks to know?
Yeah, absolutely. It was certainly a comprehensive presentation from the FTC with various speakers, including, as I said earlier, employees who have felt victimized by their very restrictive non-compete agreements, and economists speaking about how it's impacted the job market and labor market, and also attorneys within the FTC speaking on their enforcement powers. So it was a very dynamic presentation. They really emphasized, the FTC, that this administration, more than others, believes that proper law enforcement is required to prohibit unreasonable non-competes. And so although the FTC's enforcement power under the FTC Act hasn't changed, it's just this administration is choosing more so than ever to rely on that enforcement power to engage in enforcement actions. It's certainly a priority of the Trump-Vance administration. And so I think, similar to the Gateway case, we're going to see more test cases, if you will, of enforcement measures from the FTC. And we'll be able to get a better sense of what they may look like after we see a few more consent orders come out. But it's pretty clear that they're focused on the effects of non-compete agreements on competition in the market versus an employer's asserted justifications for it.
Great. Was there any other alternatives that the FTC commissioner mentioned?
Yeah,
outside of the ones we talked about?
They parroted a lot of the ones we talked about, Ryan. I think that they are, the FTC rather, is certainly making it known that employers should be considering alternatives, and that they are focused on non-compete agreements in their enforcement actions.
Perfect. And again, just to reiterate, if for any of the healthcare employers on the call, this seems to be really a focus of the federal government and the states. So if you're in that industry, I would strongly suggest taking a hard look at what you do for restrictive covenants. So I don't see any more questions. I want to thank everyone for joining our presentation. If you think of anything after today's webinar, certainly reach out to Zoe or myself, and have a great rest of the day.